Welcome everyone. Today we are discussing chapter 9 for human resource class. This is the book by McGraw-Hill. 2021 is the copyright. Again, McGraw-Hill by 2021 is the copyright. Is the publisher will be John W. Butt. Chapter 9 is contract clause and their administrations. Okay. Before we start. I need you to be quiet for a while, and I will ask the question later after the presentation is done, because this video is going to be uploaded in YouTube as well as in Edpuzzle for your interactive learning. Okay, let's start now. Excuse me. Okay, there's about 6 learning objectives for these chapters. Number 1 is understanding the nature of the United States Union contract, and Canada will be a different one. Okay. Canada is more unionized as compared to the US. Explain important contractual provision that attach right and obligation to employees, jobs, union, and employers. Number 3, outline that's how grievances are resolved, that is how contracts are administered. And number 4 is discuss the importance of grievances arbitration in United States labor relationship. And number 5, analyze the pressure or changing the nature of the United States union contract and how they are administered. Introductions. Okay, the first line is this labor union and their supporters believe that the workplace justice and efficiency are best achieved through written workplace rules enforced by private system of workplace dispute resolutions. Under the employment at will doctrine, employees are free to establish whatever terms and conditions for employment to discharge worker at any time. Unions have long sought to protect workers by resting this absolute authority. The result will be detailed, legally enforceable, union contract backed up by the grievance, ability to resolve disputes. Okay, in 50 years, the centerpiece of the United States labor relation has been union contract that specifies the rights and responsibilities of employees, the importance to understand their typical content. Moreover, in spite of the detailed nature of many contract clauses, they can never anticipate or remove every ambiguity for all scenarios that will arise during the life of the contract. What is contract administration? Basically, interpreting, applying, and resolving conflict regarding collective bargaining agreements. There's a critical process in the U.S. labor legislation that involves right of the dispute. What is the right of the dispute? Which is the disagreement over whether someone's right as specified in the contract have been violated. Well, in the U.S., focus have fought workplace justice in the early decades of 1900s, frequently tried to force their employers to follow impartial rules. Wages that are based on jobs rather than unfair condition of piece rates, promotion layoff based on seniority rather than managerial discrimination. This is the way of introducing civil rights into industry by requiring that management can be conducted by rule rather than arbitrary decisions. That's the key part of the ruling. Instead of workers' rights defended by that disrupt productions. Okay. In today's union's contract, it is legally enforceable document that specifies the law of the workplace in great detail. Some are hundreds of pages of long. Most contracts have duration of 3 years. Some contracts include reopener clause by which the parties can reopen the contract during its life to negotiate wage and benefit adjustments. Most contracts are renegotiated upon expirations. The bureaucratic model has critics, okay, from major perspective rules, based contract and the system grievances arbitration that relies heavily on past practice and present are viewed as inherent flexibility and innovation. Among some labor activities of the current bureaucratic system of the present is criticized for achieving stability at the expense of the rank and file involvement and activism. Again, this chapter will be focused on the 5 traditionally found in the U.S. labor relations, striking balance between efficiency, equity, and voice to speak rule laid out in the union contract that are enforced through formal, quasi-legal grievances and procedures. There are major components of trade contracts here. Employee rights. In terms of company rights, just cause, discipline, discharge. seniority right in layoff, promotion, etc., compensations, and fair hearing through grievance procedures. This is the employee right. And its obligation will be obey to work the rule, follow supervisor orders, abide by the contract, and accept arbitration award. In terms of job rights, job holders entitled to a certain wage rate. Strict that must be done within the bargaining unit and a certain jobs. An obligation must fulfill job standard. In terms of union rights, exclusive bargaining agent, union bulletin board in the workplace, union leader access to the workplace, shop stewards, and union undues checkoff clauses. In terms of obligations, abide by the contract, including not striking over grievances, and accept arbitrator's award. Major components of traditional union contracts, such as management right, hire and fire with just clause. Okay, this is management right. Determine job contents and workforce size. Establish production standard and rules of conduct. Decide what to produce and how and where to make it. In terms of obligation, abide by the contract, including not making little changes, just cause discipline and discharge, abide by the contract, and accept arbitrator's award. In terms of grievance procedures, employees, the union management must meet to resolve disputes over the application and enforcement of the contract. Typically, a multi-step procedures in which unresolved grievances are appealed to higher level in the organizations. The final step is frequently binding rights arbitrations. On the other side as well, contracts are legally enforceable, such as in the United States, and contracts are usually several years in duration. The employee's right and obligation, there are 4 types of employee rights. Okay? For example, number 1, just cause, discipline, and discharge, seniority rights, compensation, grievance procedures. Okay? Employee can be disciplined, discharged only for the cause and just cause. What does it mean? Cause and just cause. When this person is in the union contract, employee have the right to insist and that there to be valid and job-related reason for discipline and dismissal. Secondary for employee rights pertain to seniority. A traditional union objective is to replace arbitrary or discriminatory treatment of workers with objective standards to prevent favoritism, manipulation, and abuses. Widely used in union contract as criterion for allocating employment opportunities. Factors in promotion and transfer with more senior employee having priority over less senior one. There's third category of employee right as well. Unionized workers are more likely than the non-union employees to receive benefits. Health insurance and pension, life insurance, and the like. Numerous collective bargaining agreements contain provisions pertaining to overtime compensation, premium pay, for weekend and rest periods, among others. A majority of private sector contracts give employees the right to reporting pay and call-in pay. Again, nearly every U.S. union contract contains a grievance procedures. Employees are entitled to challenge manager actions that they feel violated their rights and under the contract. The final step of grievances is almost always binding arbitrations. Through the grievance procedures, union contract the employees the right to a fair hearing when there is a workplace problem. Okay, jobs and right obligations. Union contract confer rights and obligations to jobs. Union representing local workers frequently negotiate wages rates that are tied to specific jobs. Try to limit in terms of manager favoritism. There are certain jobs are entitled to perform certain tasks. Example, union seeks such job right because of the concern that the employer might whistle away the union represented jobs by having supervisor expand their duties. Subcontracting and outsourcing restrictions try to prevent the loss of union jobs by limiting the farming out of work to other employees. Management might try to replace higher skill job with lower skill and therefore lower paying job. In terms of union rights and obligations, the third category of clauses frequently found in collective bargaining agreement give any union rights and obligation. Recognition clause can help unions maintain in terms of strength by including new occupation with the bargaining unit. Example, unions are concerned with maintaining a recognized right if a business is sold or if the public sector operation is privatized. To facilitate communication between union and the employees union, negotiate the rights for union leaders to use bulletin boards on any company premises or meet employees at the workplace. Again, in the union clause, there's a clause shop requiring the employer to hire only union members. This is illegal under U.S. labor force, but in Canada, it's illegal. Okay, union shop require employees to become union members after hired in order to keep their job. Okay, this is unenforceable. Only dues are required. Agency shop requiring employees to pay union dues after hired in order to keep their jobs. Back right to pay less than the full union dues. Workers need to pay only the amount of dues that goes toward collective bargaining and contract administration. Figuring this out can be complicated. Right to work state, ban union, and agency shop clauses. Excuse me. Not to work equal to non-union origin shop is controversial. Union argue that workers shouldn't be allowed to be free riders because they are entitled to representations. Counter argument will be workers shouldn't be forced to pay money to any organization they don't support. Okay. Another important 2018 Supreme Court ruling, Janus versus American Federal State, County and Municipal Employees. This is in the U.S., okay? In the U.S. Agency fee, equivalent fair share fees are now prohibited across the entire process at all level governments. This has shifted the terrain of the union security debates in the public sector. In particular, conservative groups believe that members should be able to resign at any time as the labor movement wants to limit a specific time windows. Union obligation means there are various rights that the union might be granted by contract clause. It is obligated to live up to the terms of the complete contract. Unions usually give up the right to strike over grievances and instead must pursue orderly resolutions of dispute over the application of contract to grievances procedures. Union, let me just go back. Union can be sued for violating collective agreement. So union must follow the collective bargaining agreement. Duty of fair representation. What is it? A union may not arbitrarily ignore a military's grievances or process it in particular fashion in a discriminatory or bad faith manner. Applies to all bargaining units, members, even workers who do not join the union or pay dues. This obligation applies to both contract negotiation and administration, so it's frequently discussed in terms of contract administration. This obligation is universal and does not depend on the presence of specific clause in a union contract. It derives from union privilege of being the exclusive bargaining representative of the workers. Okay, in terms of management rights and obligations, okay, management right clause make it clear that management maintains sole authority over traditional management function, such as what? Hiring, firing, assigning work, determining job content, and decide what to produce and how they make it. Such clauses are found in 80% of the private sector contract, such as management rights are guaranteed by law in some public sector bargaining laws. Management rights clauses are even found in the collective bargaining agreement in which the employer is a union. Reserve the right of doctrine means that all management rights not to explicitly limited, restricted, or modified by union contract are reserved by management. Example, many arbitrages uphold the reserve rights doctrine even if the specific language is not in the contract. The detailed work rules often found in union contracts are natural reactions by organized labor to these doctrines. If management retain authority over all issues that are not limited, restricted, or modified, then union will seek the explicit limit, restrict the modified authority where it serves workers' interests. Management obligation example. Continue. This limitation, restriction, and modification largely represent management obligation under union contracts such as just cause, unity right, and etc. For the grievance procedures example, even detailed contract clause can never anticipate or remove every ambiguity of all scenario that will arise during the life of the contract. Example of contract administration will be interpreting, applying, and resolving conflict regarding collective bargaining agreement, such as equal grievances. The grievance procedure means possible method for settling grievances. One party might unilaterally control how grievances are resolved, whether it's the employer, union, or a judge. Union contract, we judge this approach. Allow multiple parties to participate in grievance resolutions. Okay, this is what in favor of the union contract. Rejection of the union approach is nearly universal in contemporary United States labor relationship. Management is unwilling to concede control to union or vice versa. So in terms of grievance procedures, the method in resolving the right dispute and grievances over the interpretation, applications, and enforcement of labor union contract in the U.S. labor relation that is negotiated into a contract. Union management control determine the whole point of a collective bargaining. Okay? Example, without a balanced dispute resolution procedures for grievances, workers and workplace justice are at the mercy of employer and the market. This is the situation the NLRA of public sector bargaining law seeks to improve upon. The typical step in unionized grievance procedures will be discussion between the employee who has grievances and his or her supervisor. If grievances remain unresolved, go to the next step. A union representative and management officials from the employees department try to settle the dispute. If grievances remain unresolved, go to the next step. If the employees of the union can further appeal to higher level management and the union representative. If grievances remain unresolved, go to the next step. The union can appeal to the step 3 outcoming of the binding arbitrations. Okay. The use of grievance procedure example provides a fair, orderly, and efficient method for resolving rights dispute and enforcing union contract. Incorporated acceptable standard and justice and due process into the workplace, such as in non-union grievances procedure can lack due to process protection as well. Employers and union benefit from continuity, consistency, and prescribed channel of the communications, giving union an avenue of pricing management to further their bargaining goal. Remember, note here, formal grievances may be inevitable in the unionized workplace, but the rate at which they emerge is not. What is right arbitration? It is ensuring that the grievance process is fair and respect workers' rights. This is also called the grievances arbitrations. It involves a hearing before a third party, neutral or arbitrator, who issues a decision that is binding on the parties and focus on the right dispute. Nearly all contracts in both of the private and public sectors include binding right arbitration as last step of the grievance procedures. There's a legal support in grievance arbitration, such as Supreme Court ruling, and to ensure the vitality and importance of the grievance arbitration in the United States labor relationship. Again, this is a U.S. based, because this book is based on the U.S. Okay, so we are using a U.S. basis book. In 1957, the court ruled the union contract contains binding arbitration as the final grievance procedure step. The employer is legally bound to adhere to this agreement and submit unresolved grievances to binding arbitration. Steelworker Trilogy example, the collective reference to the decision taken by the court in 1960, all involving the United States Steelworkers of America, provide strong legal support for the grievance arbitration process. The supremacy of grievance arbitration is when the grievances overlap the employment laws and public policies. The quasi-judicial nature of the grievance arbitration, the arbitration's sole job is to interpret, not adapt or modify the contract. The grievance arbitration is not a problem-solving exercise. Okay, the arbitrator is limited in methods and solutions. Cannot be creative, rather need to stick to the contract. An arbitration hearing is like a courtroom hearing. An executive preparation for both labor and management advocate is important. If the decision is upheld, the remedy is also awarded. Interpreting ambiguous contract language, the arbitrator task is to interpret the contract and apply it to the situation at hand. Disputes for which the contract is clear are likely to be settled nearly in the grievances procedures, so arbitrators frequently confront the difficult ambiguous matters of the interpretation. Arbitrations are based on the common law of the workplace. The written rules and arbitral custom developed in each workplace by the union contract. Contractual language, intent, and past practices. While there are many positive, there are also criticism of grievance arbitration. The bureaucratic nature of traditional grievances procedures and the importance of steward, union officials, and attorneys rather than individual workers are attacked by labor activists who are studying the rank and file involvement in the unions. It can be lengthy as well as costly. So it can also excessive legal, formal, and reactive. So it is perhaps also need the proactive problem solving in a constructive labor management relationship. Okay, the key part is constructive resolving situations. Okay, for any dispute. In terms of employee discipline, one of the most important areas of contract negotiation is the employee discipline as discharge. Employers, in particular, want to be able to discipline and terminate employees who are substandard performance. Employees do not want to lose their job unfairly. That's the key part. Most union contracts specify employees can only be disciplined or discharged for just cause. Just cause, for example, must be valid job-related reason for being dismissed or fired. Arbitration presented have developed a standard. Okay, 7 tests of just cause. What are these? The first one: did the workers know the consequence of his or her conduct? Number 1. Number 2. Was the rule, order, or standard reasonably related to the order, efficiency as the operation of the employer's business? Number 3. Was the alleged violation throughout his investigation before the discipline? And was the investigation fairly and objective? Did the investigation reveal convincing proof of care? And then, was the employer's discipline non-discriminatory? And lastly, was the discipline reasonable, related to the worker's record and spirit of the conduct? If you're doing criminal work, criminal activities, definitely ground for dismissal. That's for sure, okay? Criminal activities in the workplace, ground for dismissal for sure. Employee discipline, employee right to representation, okay? There is a Supreme Court that has interpreted the right of employees to engage in concerted activity for the mutual protection to the meaning of an employee who believes that discipline will result from a meeting with the management and can insist the union representative to be present. This is called the employee's Weingarten rights. The union representative is entitled to influence the employee, but do not to consult, not to obstruct reasonable questioning by the employers. So what does the contract values clause matters? What effect do this contract provision have? So to review that the key research on what the unions do, whether these effects are interpreted as the unfettered product of monopoly power, as the fairness or enhanced result of more balanced employment relationship, depends on the school of thought used to analyze the employee relationship. Union also grievances procedure that end in the binding arbitration to the employment relationship. The basic statistics of this grievance procedure show that they provide due process protection to the employees. Analyze what happens to the grievance and the supervisor are less favorable. What about the important effect of the performance? Organized performance. Many aspects of the contract are predicted to reduce productivity. If remember the organized performance is doing no good, of course, let's say they are losing money and they have to lay off, then that's going to be almost for sure there's major layoff. It's a common cause, it's a business issue. Many aspects of the union contract are predicted by reduced productivity. Example, control gap. The difference between restricted manager control in unionized and complete unionized control in non-unionized workplace might be more important than the wage gap in explaining employer opposition to the union. Again, what grievance procedures in a provision just cause and our fairness promoting relation might increase morale, reduce turnover, and improve productivity. The overall evidence is mixed. A fact unionism of productivity is determined by the speed of each situation, including whether managers are cooperating or confrontational. Again, non-union workplace dispute resolution, a critical difference between union and non-union United States workplace is nature of the dispute resolution. Many non-union workplaces traditionally lack formal dispute resolution systems such as open door policy, so that by default they rely heavily on manager control. Employees discuss their concern and complaints to their managers. Employees also dissatisfied by the manager responses that are free to quit. In the non-unionized workplace dispute resolution, other elements that are increasingly being added to implement open door policy. Ombudsman person example is nature as facilitator between employees and managers who help them to resolve workplace dispute. Ombudsperson, okay? And a peer review grievances can be appealed to a review panel in which employees comprise the majority of the panel members, and that the use of arbitration instead of the courts to resolve employment claims. So this is arbitration being used many times. Example in LCBO, a strike case, also arbitration. TTC is the same story. Teacher strike is the same story. Arbitrations. Okay. Reason for increased adoption of union workplace, such as dispute resolution, will be a formal dispute resolution procedure can be part of human resource management strategy to increase organizational commitment and performance by treating employees fairly and identifying problem areas. These procedures might be implemented to try to avoid costly lawsuit. Implementation of grievances procedure in non-unionized workplace might be part of non-union substitute strategy to prevent unionization. So this basically concludes our chapter. So I will upload this in YouTube as well as in Edpuzzle for your interactive learning. Thank you everyone. Bye-bye.